people. Ugh. Oh, crap. Getting us in the mood. That's right. I am the host. How am I supposed to do that? You guys ready to do it? Hey! Anybody doing Howard Dean's yell? Dun, 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 dun. Hey! Dun, 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 dun. Hey! Hi! How's everybody doing today? Good? Bad? Eh? Yeah? Yeah? Lauren, how is it pretty where you are? Where are you?
I'm in Florida right now.
Oh,
I know.
that's nice. Well, it looks lovely. Where in Florida, dear?
Fort Myers area.
Yeah, that'll work. That'll get the job done. Okay, everybody. Well, I'm so glad to see you all today. We're really just going to go ahead and jump right into it because I think that's a good idea.
I have a question, Miss
Yes,
Yoder.
love.
We don't need to know similar cases to these, right?
No, you do not.
Okay.
I know I had you guys do it. If I had that to do over again, I'd probably remove that, you know, that requirement. But, you know, it's a little, it's a little hard to think of everything, right? Okay, so I'll keep my chat open just in case anybody needs it. And we get to skip all the way to, is it New York Times Co. versus US? Yeah, great. All right, I wish I could see a few more people. That would make me happy, but I don't think I can. Oh gosh, what? Okay. Did that just get rid of my share screen? Okay, can you guys see the PowerPoint? Yes? Okay, wonderful. Okay, I've got a little button that says more chat. Yes, yes, says Elaine. Yes, says Emma. Wonderful. All right, well, I'm just gonna scoot that down. Okay, so Val, are you here or is Amanda here?
I'm here.
Hi, Amanda.
I'm a setter.
Is Val not here? Are you doing this solo?
I don't think she is, no.
Oh, no. Don't worry. You'll be fine. I will help you out. What would you like to tell us about today? Would you like to tell us about the background, the constitutional question, the decision, the impact? What sounds good to you, Pumpkin?
I could do the background of the case.
Bring it.
So this is basically happening. This case was in 1971, which happened during the Vietnam War. And this is when the Pentagon Papers got published by Daniel Ellsberg. And Nixon didn't want the people seeing this. So he stopped the New York Times and Washington Post from publishing it. But that brought up the question whether he could like hold the freedom of press from the people and violated the First Amendment.
Very good, sweetie. That's absolutely right. So guys, if you understand or remember anything about this case, if I were you, I would know that this is a, this is the Pentagon Papers case. Okay. So if you have your fabulous note-taking guide that I provided for you, because I love you, that would be a good thing to write out to the side. And like Amanda told us, yeah, you've got this dude, Daniel Ellsberg, who was assigned this task to go through kind of the history of our nation's involvement in Vietnam and kind of get some documents in the correct place that they were supposed to be. And he was so stunned by what he found. He was so disheartened by what he found, in other words, lies by the federal government to the American people, that he decided the American people should know. And I know this case is called New York Times Company versus the US. Amanda, was there another newspaper that this was leaked to? Do you happen to know?
The Washington Post.
Excellent. Thank you. And Anna, out to the side, we are writing that it's the Pentagon Papers. Oh, and Emma told you that. How wonderful. Okay, so it's the Washington Post and it's the New York Times at the same time. Actually, there was a separate Supreme Court hearing just FYI, on the Washington Post as well. Now, so the issue that Amanda told us about is freedom of the press. What reason did the government use to cite that they would like the newspapers to stop running these Pentagon papers that told the truth of our involvement in Vietnam?
He said it violated the Espionage Act.
Mm-hmm.
Oh, okay, yeah, very good. Gotta love the fact, Riley, that we're pulling out legislation from 1917 in 1971. Okay. Also, Nicole, you're mentioning national security. That's absolutely right. That's something else that we should keep in mind, right? The federal government, and who was president at the time? 1971?
Nixon.
Yes, he is. Very good, Amanda. You're on a roll. That was rolling, by the way. You're on. Okay. Yeah, so Nixon is president at the time. He cites national security and he says, please stop. But of course, guys, does Nixon really care about the national security? I mean, he does. Don't get me wrong, he does. But why do you really think he wants the Pentagon Papers to stop running?
It has information about the war. He doesn't want the people to know.
Very good. He doesn't want people to know the information about the war. It's more
like trying to save his own skin.
Yes, you're right, Anna, and Nicole agrees with you. Have you guys ever heard the phrase saving face?
That's what I
Yeah,
was
so
going
maybe nobody catches you looking like, ugh. And that's what Nixon was attempting to do. But nonetheless, we know what happened. So was this a unanimous decision, though?
No.
No,
It was not.
it wasn't.
6-3.
Yeah, good. 6-3. So did Nixon's attempt, his administration's attempt to prevent publication of what it called classified information, did that violate the First Amendment? What did the Supreme Court say?
Yeah.
Yes, it did. You can't do that. What SCOTUS actually said, they argued that the term national security itself was too vague, okay, too vague. And they said that the government did not overcome the heavy presumption against stopping a newspaper from running its story before it runs. What do we call that, guys? It's actually listed in the Constitution.
Prior restraint.
Thank you, Tori. That's right, it is prior restraint. They felt as though, they being SCOTUS, publication would not cause inevitable, direct, immediate events chancing the safety of U.S. forces. So really, the government has to let them do what they want to do. And Caroline, when you said he lied about stuff, you think you're right. He did. It was him. It was Johnson. There were a lot of people. Now, something I want to mention to you guys, and my Gov junkies out there, you're going to like this. This opinion, you know how usually it's written by one person and the rest of them sign it? And we can look it up based on who the people are. You guys know that? This one was unanimous. It was called a per curiam opinion. Has anybody come across that ever in reading anything about SCOTUS, per curiam? It's spelled P-E-R and then space C-U-R-I-A-M. And you only need to write that down if you really love the Gov. But what it means is that it's coming out in the name of SCOTUS and not a particular justice. Why do you think that might be, y'all?
Wait, I have a question.
Shoot.
If they all kind of agreed on the opinion, how come some people voted against it? Like, was there a dissenting opinion?
Yes, it was 6-3. So 3 people dissented. That's a great question, Riley. So the 6 don't want to say who they are, and the 3 don't want to say who they are. So they issued a per curiam opinion. Why?
It would make them look towards Nixon's view, or what side they were more for, or if they wanted to make him seem like that he lied, or they were for his lying or something like that.
Yeah, that's a good way to look at it. They could certainly be seen as more biased and siding with the president or being against the president, and Nicole agrees with you. Like,
Yeah, I was gonna say what Emma said. She didn't like. I feel like they kind of didn't want to out themselves because that could spell trouble, especially for the people that were dissenting. So I think it was just kind of another save face moment.
yes, you're absolutely right. It is another safe face moment. Yeah, they do want anonymity. They don't want the wrath of Nixon. That's a good way to look at that. So get this. Do you guys hear Maggie? Maggie, they're asleep. Come here, sweetie. Do you guys remember a little bit ago the Wisconsin ruling? Do you guys remember the Wisconsin ruling that SCOTUS said those decisions or the Wisconsinites had to actually vote, and Wisconsin could not extend allowing absentee ballots to come in a week after the election? So Wisconsinites were like, well, crap, what do we do? Do we slap on a mask? I mean, come on. That opinion was a per curiam opinion. Okay, I think it's a really big deal. It just shows that the Supreme Court didn't want to like own it. Although, of course, it was a 5-4 decision. So, I mean, really, ooh, I wonder who was on what side. But anyway, all right. So the significance of New York Times Co. versus the U.S. is that, I mean, this is a legit check, right, guys? This is totally the, I think it's awesome too, sweetie. This is totally the judicial branch checking the president saying no and saying to New York Times, yes. So that's kind of a big deal. I like that. It definitely strengthened the media. It definitely strengthened the push against the war, right? And guys, I mean, hopefully you remember what happened to President Nixon just a couple years after this case. Peace out, right? We had Nixon versus the US, where they said, you gotta hand over those tapes, buddy. I mean, come on, we all know what you're doing. We all know what's up. Yes, Watergate, right. Okay, I think we're good with New York Times Co. versus the US. So yes, Nicole, if the essay is about checks and balances, the Supreme Court utilizing judicial review is a wonderful example of that. And you could bring up any sort of congressional law that they're looking at or any sort of congressional action. But, you know, citing all of this stuff going after Nixon would be a great example. Yes, I'm not a crook. Okay, let's now, Amanda, great job. I know you were by yourself, so bravo. Let's leave the New York Times Co. and let's go to Wisconsin v. Yoder. Let's spend some time with the Amish, y'all. Okay, Riley, I know you're here. Nicole, I know you're here. And I don't believe I saw Seisha. Is he calling himself Timothy or Scott? Let me just fly through everybody. You're like, I don't know, Miss Utter. You have the ability to look at your screen and see. Oh, it's so good to see all of you wonderful people. Okay. Alrighty, so Riley and Nicole, y'all ready? Yeah. Okay, this ought to be fun. Yoder and Amish. One of you tell me what's going on.
So basically, there was this guy named, I forget his first name, his last name was Yoder, and it was him and 3 other parents that refused to send their kids to school after 8th grade because in Wisconsin, there was a pre-existing law that students had to attend, if they were attending public school, they had to do it until at least the age of 16. But him and these other parents said that keeping their kids in school past 8th grade violates parts of their religion, being Amish, and that they had the right to take their kids out, and Wisconsin very much disagreed.
They did. They very much disagreed. Oh, excellent. Great background information. Yeah, it was 2 Amish parents and 1 Mennonite parent. And I mean, there is a difference. I don't know. I know one of my college professors was a Mennonite, I believe. She walked to school every day on the highway and she dressed rather stereotypically garb. and had us look up dystopias or utopias. I'm sorry. That was our entire college course. So yeah, you've got those folks. They don't want their kids to go to school past the 8th grade because think of the things that you guys learn in high school. You think that would fly with the Amish faith? I mean,
No.
think of some of the outfits that you've seen while in high school. Has anyone out there been scarred like I've been scarred by some of the things I've seen? I cannot unsee them. So many butt cheeks. So many butt cheeks. What's the point? I don't get it. I don't get it. Just cover yourself. And gentlemen with these weird things. I don't. All righty. So we've got to decide what takes precedent, right? A state compulsory education law or what?
Religious freedom.
Religion.
Yeah, freedom of religion, your religious freedom. So which clause are we looking at? Are we looking at establishment or free exercise?
Free exercise.
Excellent. And everybody on your note-taking guide, I would make sure that you're writing free exercise out to the side. And it looks like, I'm glad that made you laugh. And Harper is asking me, could I say say with the rest of the cases, what would work best with the kind of FRQ I did? Harper, can you unmute yourself and ask me that?
Yeah, sorry, it didn't make sense. I was trying to figure out how to say it, but like you said, New York Times versus US, and you said that it would work well with like an FRQ that was asking you about checks and balances. Could you, I mean, it's kind of obvious with this one, but like, could you do that with the next few too?
Yes. Oh my gosh, absolutely. What a lovely idea. And Kira, I'm glad I made you laugh. Okay, so let's see here. Our issue is, did Wisconsin's requirement that all parents send their kids to school until the age of 16 violate the First Amendment by criminalizing conducts of parents who refuse to do so for religious reasons? Or in other words, does the free exercise clause override state compulsory education? And Nicole, you're nodding at me. Why are you nodding?
Well, they voted unanimously that it was unconstitutional, and they used the free exercise clause stating that it prohibits them from actually like developing their religious beliefs and becoming a part of their community. And then they used the due process clause of the 14th to force the states to basically agree and like comply with the First Amendment.
Excellent, sweetheart. Thank you so much. You're absolutely right. And I love that it was unanimous, yet it was 7-0. Did you and Riley happen to see that when you were doing your research? So Powell and Nyquist. You did? Do you know why?
Yeah. Well, because 2 of them abstained. I mean, I just kind of assumed that it was because they didn't want to vote on, because it's really a controversial issue if you're kind of religious.
Yeah.
So I think they just didn't want to like out themselves as feeling either way.
Okay, that's a good idea. And whenever we see a court case that doesn't add up to 9 in recent times, it was either when Antonin Scalia had passed away and we hadn't filled the vacancy, or some justices simply recused themselves and decide not to participate in the decision. In this case, it was because these 2 men were not on the Supreme Court during oral arguments, so they couldn't participate yet. Isn't that interesting? So I mean, if you're sick and you miss oral arguments, or if you miss the weekly conference, you cannot participate. You can't. Yes.
If one person abstains from SCOTUS, and what happens if it's like 4-4? Has that ever
Know
happened?
the answer? Does anyone know the answer?
Yeah. It goes back to the lower court's decision, but it doesn't set any precedent.
That's right. That's right.
That's cool.
Yeah, I mean, it's fascinating. So the lower court's decision stood, even though the Supreme Court is hearing it, they're not making any change, right? So it's not technically stare decisis, but it's similar. Good questions.
Wait, Miss Etter, I'm kind
Yes.
of confused on the ruling.
Okay, Pumpkin.
So the court said that like the kids don't have to go to school after 8th grade.
Correct.
Okay.
The free exercise clause of the First Amendment supersedes state compulsory education laws in this instant.
Okay.
Thank you.
Yeah, you're welcome. Oh my gosh, yes, that's why I'm here. Literally, it is why I'm here. So the SCOTUS made a point to look at the long-standing traditions of the Amish community and how long they've been around. And it wasn't just, like some new fangled religion that's saying, we don't want our kids to go to school. But SCOTUS said that the values and programs of secondary education are found in sharp conflict with the fundamental mode of life mandated by the Amish religion. So it's just not gonna fly. Okay. We good on Wisconsin v. Yoder? I think any of our FRQs ask about the First Amendment's free exercise clause. That's a case you should cite. Just like what case would you cite if it asks about the Establishment Clause?
Angle.
Engel versus Vital. Very good. Linz, do you have a question, sweetheart? No? Okay.
No,
Sorry.
no, sorry.
That's okay, but you are up next. And I don't believe I've seen Caroline Harrison. Caroline, if you're here, speak up. Sarah, are you on? If anybody's friends with them, text them. Okay, ladies and gentlemen, please let me just state for Lindsay. Oh, Lindsay, look, Zara's giving you a shout out. So let me just put this out there for Lindsay. Everything that Lindsay is getting ready to tell us may or may not be her personal opinion. This case is about the most controversial issue in our government today. It was the most controversial in 1973, and what do you know? It still is today. So Lynn, sweetie, what do you want to tell us about?
I can talk about the background if you want.
I would love that, please.
Okay, so Norma McCorvey, who went under the alias of Jane Roe, wanted to get an abortion in Texas. And so in Texas, they were kind of like, it depends on the circumstance. So Henry Wade, the district attorney, was like, no, you can't get that. So she filed a lawsuit saying that it violated her right to privacy and her rights guaranteed to her in the 14th Amendment.
Very good, honey. That's right. Yeah, the Texas law at the time was a woman can only get an abortion with a doctor's note. In other words, save her life if necessary. And she said that she had a right to privacy. She said it in that it wasn't necessarily stated specifically, but it was inferred from the First Amendment, Fourth Amendment, Fifth Amendment, Ninth Amendment, equal protection from the 14th Amendment. I mean, dang, that's a lot, right? Now, here's what's interesting. The first thing that the Supreme Court had to determine before they looked at the case specifically was, is the case moot? Do you know what that means, moot? Not mute, M-U-T-E, but moot, M-O-O-T.
Like, it's not necessarily like, it might not be relevant in a way, kind of. Is that right?
It is, sweetie, that's totally right. Is it not relevant anymore? Because she was no longer pregnant. So if she's pregnant, do we need to look at this anymore? She can't get the abortion. Do we need to look at this anymore? So here's something interesting. In addition to finding, the Supreme Court said that pregnancy is classic justification for conclusion of non-mootness. That's a word, everybody. You've learned something new today. Because if something is not moot, if it's capable of repetition, evading review. So can a person get pregnant again? Usually, yes. So interesting. Okay, so great. Lindsay, what's our question here essentially?
So it was pretty much, was it constitutional for Texas to restrict women from getting abortions despite the Equal Protection Clause in the 14th Amendment?
Oh, that's
like, is there a part in the Constitution that says if that's illegal or not.
Correct. Very good. If we want, we can even make it nice and simple. Is abortion constitutional? Or restricting abortion constitutional? So everybody, we have a 7 to 2 decision here. And by the way, a lot of people think that, oh my God, what's her name? Oh, nobody tell her, I forgot her name. Sandra Day O'Connor. A lot of people think that Sandra Day O'Connor, the first woman justice on SCOTUS, was on the Supreme Court at the time. She was not. So this was a decision made by 9 men, okay? They said, get ready, it's the due process clause of the 14th Amendment that gives the fundamental right to privacy. Because remember, the due process clause of the 14th Amendment says states cannot deny a person of life, liberty, or property without due process of law. In this case, it's probably liberty that they're referring to. And Lindsay, was the impact or significance an easy thing to determine? Or did you find—
Sorry, you were a little, will you repeat that? You're a little glitchy. Sorry.
Oh, I'm glitchy? Well, that's okay, because Willow's favorite Disney princess is glitchy too. What's the girl on Ralph? Honey, what's the girl on Ralph?
Vanellope. I literally watched it last night.
Hannah.
Like, no joke.
Did you really? Oh, that's cute. All right. Yes. Okay. So Vanellope. Ooh, Autumn corrected us. I think she's right. She's right.
No, it is Vanellope.
It is Vanellope. Okay. Look, we're all agreeing. This is adorable. Yes. No. I think you're right, Autumn and Anna. All righty. So, okay. This is a big deal. Get ready. And you do not need to write all of this. Okay. Abortion is protected the first trimester in every state. Okay? That's what you should know. Abortion is protected in the first trimester in every state. No state can deny a woman the right to terminate her pregnancy if she wants to in that first trimester. And it's called a trimester because a pregnancy, a woman's gestation period, is divided into 3 trimesters. Okay? And it's all so fun.
Wait, I thought some states took that away now.
Ooh, was that Harper?
Yeah.
Okay, so some states have tried.
Oh, yeah.
Federal courts have ruled that they cannot. But there is a case, yes, like Georgia, that's right, with the heartbeat law. And yes, Emma agrees with you. SCOTUS is looking into an abortion case right now. It was one of the 36 that they had still on their docket to hear before they dipped out. Yes, Alabama's another one. Pretty much it's the southern states, guys. Okay. All right, so here's what they said, and this is more in depth. You don't need to write this down. Like I told you, in the first trimester, the state cannot regulate abortion. This is just FYI. In the second trimester, the state may impose regulations, but they have to be reasonably related to maternal health. Okay? And then the third trimester, once the fetus has reached viability, what do you think that means?
The ability to just survive out of the womb, like
Correct.
On its own.
Very good, very good. And it looks like you're not the only person who knows that. Yes, can survive. Excellent. Once the fetus has reached viability, the state may regulate or prohibit it entirely, as long as there's an exception where it's necessary to save the life or health of the mother. So every state has to have that, and every state has to allow a woman the right to choose in that first trimester. Okay? Now, in more recent Supreme Court cases, oh, thank you, Emma. Thank you for the reminder of Ohio. You're right. Other things have popped up. There is this case called Planned Parenthood v. Casey, which looked at abortion as well. And Lindsay, did you read about that one in your research, honey?
I did.
Yeah.
It was pretty much saying, like, it was in Pennsylvania, and they were saying that they had to have all of these requirements, like they had to inform the father or if they were a minor, they had to get consent from the parent, and they had to do all of these things. And so like the question that was being asked was like, is this too restrictive? Like, does this require too much? Like, does this go against the Roe v. Wade ruling?
Very good, Lindsay. Very good. Yes. Do these new rules create what is called, you might want to write this down, an undue burden? An undue burden. And specifically in versus Casey, they were looking at, like Lindsay said, the minor has to seek consent from a parent, or a spouse has to have consent from their husband. There has to be a 24-hour waiting period. Now, of those things, only one was found to be, she is killing it today, only one was found to be unconstitutional. So I'll list those three again, and you don't need to know this. This is just FYI. Minor must inform a parent, spouse must have consent from a husband, and 24-hour waiting period. Which one of those three do you think SCOTUS found to be unconstitutional?
The husband one.
Yes, Riley. Why do you think, honey?
Because if you're a minor, it's different, I guess. I mean, if you're like 14 and you're pregnant, it's still a medical procedure.
Yes. Yes,
Yeah.
absolutely, sweetie. And a 24-hour waiting period. Why do you think they didn't find that to be an undue burden?
Because 24 hours isn't enough time for anything significant to happen in a pregnancy, I guess.
Yeah. Why do you think they came up with that waiting period, guys? What do you think the purpose of that was?
Probably to allow someone to think about the decision.
Like question the morals of it.
Y'all are amazing. Very good, very good. Anna, very good. Harper, Grace, Anna, Riley, Lindsay, good job. Roe versus Wade, shall we? Shaw versus Reno. Okay, Autumn, I know you're here today, so step up to the plate, dear, because I don't believe I saw Haley and I don't believe I saw Michael. But good news.
I'm here, Miss Utter.
Who's here? Michael! Yay, Michael, I'm so glad to hear you. I'm sorry I can't see you, but I'm glad to hear you. All right, so Michael, since I just saw you, I'm going to let you pick. What are you going to tell us about? Background, constitutional question, the decision, what?
I'll do the background.
Bring it.
So in 1990, after the 1990 census, North Carolina gained another district, and they had not had an African American in Congress in the 20th century, even though 20% of their population is Black. So in order to gain an African American in Congress, they created a minority district, and Janet Reno rejected the plan because she said there needed to be another minority district.
Mm-hmm.
So they created 2 minority districts. And then a group of citizens led by Ruth Shaw sued the federal government because they said that the districts violated their 14th Amendment Equal Protection Clause.
Well, that was just lovely. Very good, Michael. And you even got all the names right. Janet Reno was the Attorney General at the time. And by the way, if you have never seen her portrayed on SNL, Will Ferrell does it, and it's a thing of pure beauty. You should check it out. I mean, really laugh out loud.
It's absolutely hilarious. I love that.
It is. It is. Okay, so excellent background information. Yes. So North Carolina then presented 2 majority-minority districts. That's the term that you should all write down, majority-minority districts. And I provided a picture for you on this PowerPoint slide. You can see. Okay. All righty. So let's see here. Autumn, do you want to tell us the constitutional question or what's at stake here, or would you rather cover the ruling, my dear?
Yeah, sure, I can do that. So
Bring it.
basically, it was that whether the North Carolina residents claim that the state created a racial, this is directly from the site that I used for research. Did the North Carolina residents claim that the state had created a racially gerrymandered district raise a valid constitutional issue under the 14th Amendment's Equal Protection Clause?
Excellent. That's absolutely right.
Those are not my words, so those words.
No, you're fine. You're fine. I mean, really, it's okay. So these folks who are mad about this majority minority district are claiming that it violates the Equal Protection Clause of the 14th Amendment. Hey guys, think about when the 14th Amendment was ratified. What had just taken place that was pretty, crucial in our nation's history?
Slavery.
Yeah, the Civil War, absolutely. Slavery had ended. So remember, and thank you, Autumn, and thank you, Nicole, you're correct too. So remember, guys, this amendment was in part protected, or was for the vast majority of its logic and reasoning created to protect the rights of freedmen and women. But what's interesting in this case, and why Autumn was falling over herself apologizing for what she was saying, which were not her words, is because you have a group of white citizens claiming that they're experiencing discrimination and their equal rights are not being protected. Do you guys follow that? Hey, Autumn, what did SCOTUS say about it?
They like that, although the new shape, like the new district was like quote racially neutral, like on a surface level examination, the shape of the resulting district was strange enough to suggest that it constituted an effort to separate voters based on their race.
That's absolutely right. Very good. Michael, do you remember the ruling?
The ruling was a 5-4 ruling.
Oh, I love a 5-4. I love it. It's so exciting. Yeah, so SCOTUS said, you know what? The shape is so messed up here. It's so odd. Obviously, you're trying to separate voters in different districts based on race. So guys, does this violate the Equal Protection Clause? Yes, it does. It doesn't say Equal Protection Clause looking out for minorities. It doesn't say that. That might be what it was intended to do, but it's the Equal Protection Clause. Interestingly enough, feel free to write this down if you want to. This interpretation of the Equal Protection Clause was also used to support a white medical student's claim that he experienced reverse discrimination in terms of college admittance. And that's the Regents of the University of California versus Backey affirmative action case, which found that affirmative action is okay. Using race as a consideration is fine, but having a number system, that's not okay. And this case said something very similar. Utilizing race as a factor in making a decision to draw those district lines, that's okay. But it being the only thing that's used, that's not okay. And what do we call it when we draw those district lines in a way to benefit one party?
Gerrymandering.
Gerrymandering.
It's the best word, isn't it? It's just the best, gerrymandering. I mean, it's a terrible thing, but it's the best. And so we can see, obviously, that it can be done by both parties. Very good, Michael. Very good, Autumn. Let's leave Shaw versus Reno. And guys, we've got 3 more. Let's do US versus Lopez. So I swear I've seen Kylie, right?
Yes, I'm here.
Hello, lovely. And you don't have your glasses on. Are you okay? Can you still see?
Yeah, I just can't see from a distance. So I
Oh,
can see.
pumpkin. Oh, you're fine. You don't need to put them on. I was like, oh, where's Kylie? And Anna is here as well. So Anna, say something.
Hello.
Hello. Okay. And you know what? Zach Zaire and Ian Mays are not here. So if you have their numbers, feel free to shoot them a funny face emoji or, whatever. It's up to you. This case is so interesting, right, Anna and Kylie? Because you think it's about gun control, but is it?
Not really.
Thank you. No, it's not. No, it's not. Good. All right. So which one of you guys wants to give us the background info?
I can.
Thank you, Anna.
So a high school senior named Alfonso Lopez went into his high school in San Antonio, Texas with a firearm, and he was charged with a state law that violated having a firearm, but the charges were dropped and he was instead charged with violating the Gun-Free School Zones Act, which is a federal law stating that you cannot have a firearm or possession of one in a school zone. But there was a big issue at whether or not that schools, because schools technically are under federal government and they're under the local governments, so it was a question on whether or not that law was constitutional.
Lovely. I mean, I'm just so pleased with what an amazing job everybody is doing today. It's making me, it's filling my teacher tank, so thank you. Good. Yeah, so this dum-dum brings a gun to school, not okay. And like Anna said, the state charges him with doing so, but then the charges are dropped. And maybe for a brief second, Alfonso, who was a senior, by the way, thought, oh, whew. But no, instead the federal government is bringing charges against you, buddy, because you violated, like Anna said, the Gun-Free School Zones Act of 1990. Now, so they're saying he violated a federal law, okay? So what's the constitutional issue then, Anna and Kylie?
The constitutional question was, did the Gun-Free School Zones Act demonstrate Congress overstepping their powers, making it unconstitutional?
Yes, very good, very good. Did Congress have the power to make the Gun-Free School Zones Act? Whose purview are schools usually under? States. Yeah, it's states, right? States get to make the decision, okay? But in this case, Congress is making the decision. And Kylie, how did they feel they had the right to do that? What clause did they cite justified them doing so?
The Commerce Clause.
Very good. Very good. What is commerce, y'all?
Trade between states.
Trade. Yeah, it's trade. Anything that has to do with, very good. Everybody's chiming in. Shia, Grace, Caroline, Gabby. It's trade, right? So Kylie and Anna, tell me, how do guns fit in with trade?
This was kind of the big issue because some people said that it didn't really have anything to do with trade, while other people claimed that guns can impact commerce, especially locally, because it can impact like whether or not people feel safe in that area and if people want to put money into that area, or whether or not crossing lines with the firearm.
Very good. I mean, you gotta love Congress for trying, right? They've seen so many Supreme Court cases where their power is expanded, specifically for the Commerce Clause with Gibbons versus Ogden back in 1824. And then with McCullough versus Maryland for the Implied Power Clause, Necessary and Proper Clause. So they're used to being able to spin these clauses to get what they want. But this time, what did the Supreme Court say, girls?
No.
No. No. You can't do that. What kind of decision was it?
It was a 5-4 ruling.
5-4. Yes. Very good. So here's what I wrote down when I was doing a little bit more research. So they ruled that having a gun in a local school zone is not an economic activity that might have substantial effect on interstate commerce. The law is a criminal statute. It has nothing to do with commerce. So then what happened to the Gun-Free School Zones Act, Anna and Kylie?
From what I found, they changed the wording and like basically amended it to say something different.
Very good. Very good. And do you guys know what happened to Mr. Lopez? I do. If you don't worry.
I don't know.
That's okay. It's not like you got a get out of jail free card here. Okay. That doesn't really happen. He was tried on state charges instead then. and he got in big trouble. Big trouble.
Wait, Miss Eder, I have a question.
Yes, Lauren?
So, basically what the issue was like, they said that Congress was overstepping the state's power. So SCOTUS ruled that like they were overstepping.
Yes.
Okay.
Yes.
So it gives the power to the states.
Yes, that is correct. Congress trying to say that this is their power through the Commerce Clause is bull. It's not their power through the Commerce Clause. They can't do that. Remember in Marbury versus Madison when the Supreme Court said to Congress, you can't give us that power? No, they're doing the same thing here. They're saying you can't do that. You cannot do whatever you want just because you think you can spin these words and give yourself the power to make this legislation. You can't. It's up to the states unless you revamp your wording a little bit.
Okay, thank you.
Absolutely.
So, Miss Eder.
Yes, love?
The reason that they couldn't use the Commerce Clause was because he was trading the gun, right? That's why he brought it to school. He brought it to give it to someone. And that's why they tried to
claim
use
that.
the Commerce Clause.
Yeah, he did claim that, Harper. I'm so glad you remember that, right? He did claim that that's what he was doing, that it wasn't for use, it was for sale. I mean, you guys realize that is an important distinction in our criminal laws, right? Especially with possessing or intent to sell. So he also tried to use that argument, but that just kind of fit into the case. The real issue was, can Congress make this law claiming that they're doing so to go after trade? And the answer is no. Okay, very nice job, Kylie and Anna. 2 more, everybody, 2 more. And listen, this next one is, there's a lot to it. So I'm going to help Lauren and Riley. And Katie B, are you here? No, she was here on the other day. I'm going to help Lauren and Riley as best as I possibly can, kind of like skim it down. Does that sound okay, Lauren and Riley?
Yeah.
Lauren says yes. Riley, what about you?
Yes.
Yes. Okay, good. All right, so everybody, it's time for Citizens United versus the FEC. Get excited. I'm excited. You're excited. We're all excited. Okay, Lauren, what do you want to tackle? You want to do background?
No, I can do the questions.
Okay, great. So Riley, do you want to do background?
Yeah, I'll do that.
Amazing. Tell us about it, sweetie.
Okay, so basically before this happened, the Bipartisan Campaign Reform Act was in place, which basically said that corporations couldn't spend their treasuries couldn't spend their funds on campaigns like 60 days before the elections or 30 days of a primary. And so Citizens United was a nonprofit conservative group who wanted to air a documentary about Hillary Clinton, but portraying her in a bad light.
Yes.
And the Federal Election Committee basically like threatened them saying, you can't do that. And so they
Yeah, and they said, yes, we can. Why? Why did they claim that they should be able to do it, Riley and Lauren?
Because of the First Amendment and they have the freedom of speech.
Excellent. Very good. And y'all, if you have not seen segments of Hillary, Tori, do you remember when Henry showed us a little bit of it?
You never let us have our movie night, Miss Eder.
I forget these things. I forget these things.
Oh my God, it was like so funny.
It's pretty blatantly biased, to put it lightly. So yes, Riley, great intro. So basically the issue here, like you said, is that this group, Citizens United, wants to air this documentary, this feature film essentially, that is against Hillary Clinton, and she was running as president. But there are these rules, these laws in place that say interest groups can't use their general treasuries to fund electioneering communication. That's the phrase that I would know if I were you guys, electioneering communication, okay? And electioneering communication is just, referring to anything having to do with campaign advertising. And there was a reason why they didn't want corporations and unions to be able to use their general treasuries to make campaign ads. What is that reason? Think of how much money Coca-Cola has. Think of how much money Home Depot has. Home Depot right now, I'm sure everybody in your neighborhood is doing home improvement projects too right now.
They can have like a bigger impact, and because the media influences people so much that just because they have all this money, they can basically run a like something that everybody's going to see, whereas other opinions and other groups may not get shown as much.
That's right, Nicole. They've got so much money. Caroline agrees with you and says more money, more power and influences. You're both correct. That's the issue that they had been trying to avoid for such a long time now. All right, so Lauren, tell us then, what is the constitutional question?
Does them like ban this ad go against the First Amendment?
So yeah, does that section of the Bipartisan Campaign Reform Act limiting corporations and union violate the First Amendment? Because guys, we've said that speech goes beyond just talking, right? What are some other things that we found to be speech?
Burning of the flag.
Burning a flag, very good. What else? Armbands, Autumn says. Symbolic speech, very good. Tinker's armbands. Okay, so there's plenty of other things that are speech. What do you think about giving money to a person running for office? Can that be considered a form of speech?
Yes.
Yes, and they call it campaign speech. So what did the Supreme Court find, Lauren O'Reilly?
It was a 5-4 ruling towards the Citizens United, and it basically said that like they can show it because it does violate the First Amendment. No, it does not violate the First.
No. I'm sorry. I just got an alert on my phone that is weird. Yes, very good. This part of the Bipartisan Campaign Reform Act, Lauren, does violate the First Amendment for unions and corporations. SCOTUS essentially said they have people in them. People have free speech. They should be able to spend their money how they want to spend their money. And I believe it's what got Mitt Romney into some, didn't I show you guys that Stephen Colbert Super PAC video where he played the clip of Mitt Romney saying corporations are people too? And there's plenty of people who feel that way. And I mean, they're fine to feel that way. But this decision was really controversial. President Obama called out the Supreme Court at his State of the Union address the next year. How awkward is that? They're sitting in the front row, and of course they're very stoic, you know, cannot show any emotion. And President Obama is essentially doing this to them, and they're just going, And that was not a per curiam opinion. It was not. So everybody, the significance here is that corporations and unions are now free to spend their money how they want in electioneering. And we have the advent of the super PAC. The PAC, but the super PAC. Now, do you guys recall how the super PAC is limited?
They can't communicate directly with people like in the campaign.
Excellent, Tori. They are not to take specific direction from the candidate that they are supporting. Excellent. But of course, sometimes the people who are placed in charge of the super PAC are, you know, the lawyer of the person that they're supporting. It's interesting. It's interesting. So, yeah, big deal. Okay, Lauren. Okay, Riley, good job. Does anybody have a question on Citizens United? As long as you know super PAC, corporations and unions can now spend money and are not limited, you should be okay. Ladies and gentlemen, last case. Last case, are you ready? Melody, I saw you here, my darling dear. Will you say hello to us?
Hello.
Hello, Melody. McDonald versus Chicago. I'm sorry Andrew is not here to help you out today, nor is Natalia, unless she walked in. Oh, look, Emma's giving you some love. Go, Melody. Grace agrees. Isn't that so nice? I'm telling you guys, your class is really special. You guys are. When I got back from maternity leave and in class somebody would answer a question correctly and you guys would give each other fist bumps, I was stunned. It was so wonderful. I told all my friends about it. I said, oh my gosh, this class is so great. Because you are. Okay. All right, enough reminiscing. I'll get sad. Let's do McDonald versus Chicago. Melody, what would you like to tell us? You pick.
I can do the background.
Great, and I'll change the slide.
Okay, so Otis McDonald wanted to have a handgun for self-defense, but Chicago said no because they had strict rules barring handguns. So he sued the city of Chicago, saying that that his right to have a handgun was it was his Second Amendment right to have a handgun.
That's right. And Melody, did you happen to read how many times his home had been broken into?
I think it was twice.
Yeah, I mean, that's a lot. That's a lot.
Yeah.
And if he wants to have a gun to protect himself, he feels as though he should. So good. You are looking at the question, should the Second Amendment apply to states? Now, here's the reason. Okay, so did you read about DC versus Heller?
Yes, yeah.
Yay. Okay, can you tell us a smidge about that?
So DC, there were laws which said that they couldn't purchase, or they couldn't put a ban on handguns because DC was but then it was overruled because DC is a federal city, so the Bill of Rights applies directly to DC.
Nicely done, Melody. So to understand McDonald versus Chicago, we have to understand DC versus Heller. DC versus Heller was in 2008. McDonald versus Chicago was in 2010. And like Melody just told us, in DC versus Heller, Mr. Heller, a police officer, by the way, in Washington, D.C., wanted to have a gun for himself. And so the Supreme Court said, yes, you should be able to have a gun for yourself because the Second Amendment says that Congress cannot deny that to you. And Washington, D.C. is the District of Columbia. So now we have to consider whether or not to do what to the Second Amendment. What do we call it, guys, when we make the Bill of Rights apply to the states?
Incorporate.
Incorporation.
Very good. So yes, Nicole, this set the precedent that the Second Amendment does mean that individuals can have guns and the federal government can't take them away from you. But they hadn't yet said that the state government cannot allow individuals to own guns. Excellent. Good. Okay. So everybody, like Melody has told us, this is the incorporation case. What was the ruling, sweetie?
It was a 5-4 ruling in the favor of Otis McDonald.
Yes, another 5-4, and yes, the Second Amendment should apply to the states through what amendment, folks?
14th.
Yes, Julius, what clause?
Due process, baby.
Very nice. Very nice. Now, I'm going to tell you guys this because it's kind of funky. People look at the Second Amendment with different eyes. Is it an individual's right or is it a collective right? Does anybody know what I'm talking about?
Well, it talks about the militia in the Second Amendment. So that's when people are like, is it really an individual or is it like a militia thing?
Correct. Correct. So, hang on. I think Willow stole my pocket constitution.
I can read it. I have it out.
Thank you, Pumpkin.
I just have to find it.
I know. There's a lot.
Got it.
Great.
A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed.
Thank you. Thank you. Thank you, Tori. So is it a collective right or is it an individual right? So if, oh, that's a nice compliment from Harper. Is the right there for the militias to defend the state against the federal government, or is the right there for individuals to protect themselves against the government? It wasn't until 2008 that SCOTUS found that it was an individual right. Does that blow anybody else's mind? Just me.
I mean,
interesting. Yes.
Like, I'm kind of surprised that it took so long for somebody to like point it out, and the fact that there's this discrepancy and nobody really knows what the answer is until the court decides, because that's the law.
I know.
Like 250 years after we were declared.
I know. And this is one of like the American liberties, y'all. I mean, people are diehard for religion and speech and guns, right? Wouldn't you say those are probably the three most treasured? I mean, I don't think people often say, I love my right to assemble. I just don't. I don't think we see that one too often.
People are saying it a lot more now.
Oh, Tori, but I had my sound effect ready. I had it on the PowerPoint, but I didn't have it ready today. Crud. I'm glad you love your right to petition the government, Autumn. That's wonderful. So everybody, that's our most recent incorporation case. And and question 2 asks about incorporation, I would use case as a good example. Or of course, you could always go with Gideon. Hey, speaking of Gideon versus Wainwright, incorporation of the 6th Amendment, has anyone out there heard of Ramos versus Louisiana? I think a few of you have. SCOTUS issued a decision this Monday that said that jury decisions in big deal cases, like serious cases, have to be unanimous. Just FYI. It really wasn't super duper shock waving, but SCOTUS hadn't decided to consider it before. But once Justice Kavanaugh stepped onto the bench, the rule of 4 applied, and so they did hear it. And they did say in a vote of 6-3 that jury decisions in significant cases have to be unanimous. Only 2 states had it to where they didn't have to be. Louisiana, obviously hence the name, and Oregon. So Mr. Ramos was found guilty of murder in a 10-2 verdict, and so now he's going to get another trial. And do you know what happens if they don't get a unanimous verdict?
Mistrial?
Mistrial, that is right. So there you go. Okay. Yes. All righty. So everybody, hang on. Stop share. So everybody, those are your 15 SCOTUS cases. How do you feel?
Good.
Yeah. I love seeing all these up. It is wild stuff.
What's the, so you mentioned that the second question is where we could use like a Supreme Court case. Is it only the second question where we would bring in another case? Like what are the 2 questions going to be again?
Sure. There's a lot of change going back and forth. So question 1 is a question you're going to have 25 minutes to answer, and it's the modified argumentative essay. and it's going to cover those 9 foundational documents. So next week, we're going to have a review where we cover all 9 foundational documents pretty quickly, but it'll be just fine. And that'll be a good review for you guys to attend. Me too, Nicole. So Harper, you could certainly mention if the foundational document question, argumentative essay, is talking about the executive branch, and it talks about Federalist 70, the energetic executive, you could always throw in some other Supreme Court cases involving energetic presidents like Nixon versus the US. And you could cite that case as something that Hamilton would have wanted to prevent, you know, or any other case having to do with the executive power. You could cite the Worcester versus Georgia case where Andrew Jackson ignored the ruling.
Okay, so it's like, if I remember right, is it like they give you a list of documents in the argumentative essay, and you have to choose one of them? Yeah, you have to choose 2. Okay,
Oh,
and then
you have
so you choose
2 different documents.
Yeah, well, in the argumentative essay.
Yeah, so
I
they'll
thought they
give you
did
3.
Yeah.
And you have to use one of the 3, and then you have to bring in a second document, which could be one of the other 2 remaining documents, or it could be any other document from the 9, or any governmental concept, or any of these cases.
Yes, okay, thank you.
Of course, my dear. And then you might be able to use them in the second question. It's just like all those practice FRQ question 1s where it's asking you about a governmental concept. And to strengthen your answer, you could potentially throw in a court case there. Okay. You feel good about today? You know we're not Zooming tomorrow, right? I apologize. I know I messed up, but I'm going to the mountains, and I don't want to Zoom in the mountains. Love you, mean it. No offense. All right, so nobody else has a question? Well, I'm going to leave you with,
it's not
yes.
related to the cases.
What, Kira?
So because the Zoom isn't tomorrow, is the Birmingham letter still due tomorrow, or do you want it?
No, Monday's fine.
Oh, okay, thank you.
Yay, you're welcome. Anything to make you happy. All righty, so I'm going to play my favorite 80s rock song to lead us.
Kickstart my heart.
It is, Julius. Oh, Julius.
Yes. I still remember.
I'm glad you do, sweetie. So, ladies and gentlemen, this is Motley Crue wishing you a wonderful day. You kickstarted my heart today. It was a wonderful Zoom. I love seeing each and every one of you. And I'll see you Monday. Okay? Bye. Bye, sweetie. Oh, cute puppy.